Hi, I'm Neil Milton. I want to talk briefly about the non-resident estate trustee. By that I mean an estate trustee who does not live in Ontario. There are two totally different circumstances, with a will and without a will. If there is no will, then it's quite difficult to get appointed, virtually impossible, but not totally impossible to get appointed as the estate trustee. So for an intestacy, we have succeeded on many occasions when the estate is very simple and the beneficiaries are very simple and the liabilities are very simple and the proposed estate trustee resides in Canada, just not in Ontario. Otherwise, if you don't have someone, you need to find a friend or family member who will act, or choose a third party who's qualified and experienced, someone like our firm or a trust company to act as the estate trustee. In the case of a will, it's very different depending on whether the proposed estate trustee is named in the will as an executor or not. If they're named in the will, and especially if they reside in Canada, there is absolutely no reason they shouldn't act. And so don't get bullied into resigning simply because you're one of the executors, but you don't happen to live in Ontario. There are good reasons to hang on and stay often. Sometimes it makes sense to step aside and let someone who's resident in Ontario administer the estate, but don't get bullied into resigning simply because you live in BC and the estate is in Ontario. More problematic if you are going to be the estate trustee but are not named in the will, and can be quite challenging even if you are named in the will but live somewhere where it's difficult to get the court to agree to dispense with the bond. A properly drafted will, however, will make it clear that no bond is required. So you can live in South Korea and be appointed as the estate trustee in Ontario, especially if the will makes it clear that no bond is required. I hope that's helpful. If you have questions or concerns, send us an email. We'll get right back to you.